I studied UCC contract formation and terms. While studying this week's case brief, I learned that in UCC, a buyer must notify the seller of a breach within a reasonable time and discovering the issue, after the discovering the issue. Failing to do so may bar the buyer from seeking any remedy. So it is the buyer's responsibility to notify the seller promptly. As a personal takeaways in this week's study about UCC, I figured out the difference between common law and UCC regarding consideration. In contract law, consideration is something of value that each party agrees to exchange as part of the contract. It can take many forms, such as money, services, goods, or a promise to do or not do something. In the UCC, modification to contracts for the sale of goods do not require new consideration as long as the modification is made in good faith. This is different from common law, which would typically require new consideration for any contract modification. Article 2 of the UCC governs contracts for the sale or lease of goods. UCC only applies to the sale of goods. It does not apply for sales of real estate, services, or stocks. The rules can vary depending on whether one or both parties are merchant. What is a sale? The UCC defines a sale as the passing of title from the seller to the buyer for a price. At a price. A gift is not a sale. What is good? To be considered a good, the item must be tangible and movable. A movable item can be transported from place to place. A standard home, while tangible, cannot be transported because it is fixed in the ground. Therefore, it is not a good. A mobile home, for example, in contrast, can and is designed to be moved, making it a good. You will occasionally find contracts that involve both goods and non-goods. In such situations, you will have to employ the predominant factor test to determine whether the sale is primarily for the goods or the services. If you determine that the main focus of the contract is for the goods, you will use the UCC. Who is merchant? Merchants have a higher level of sophistication and therefore should be held to a different standard than those that are ordinary or inexperienced buyer or sellers. The UCC defines a merchant as one who deals in goods of the kind involved in the contract, holds himself or herself out as having special knowledge and skill regarding the practices or goods involved in the contract, or employees a merchant as a broker, agent, or other intermediary. An example would be a coin collector who hires a coin broker to purchase special coin. In this example, the collector would be considered a merchant. Offer under the UCC, in general contract law, the contract is formed and the moment that the offeree accepts the terms indicated in the offer. The UCC charges this by recognizing as valid some agreements where the terms are vague or open. Under the UCC, an agreement will not fail so long as the parties intended to make a contract and the court can find a reasonable certain basis for giving an appropriate remedy. Open terms. If the parties have not agreed to a price in an agreement for the sale of goods, the UCC allows a court to determine a reasonable price at the time of delivery. When parties do not specify payment terms, the UCC indicates that payment is due at the time and place at which the buyer is to receive the goods. Some contracts speak of successive performances, but don't indicate how long the contract will last. When there is confusion about the duration of an ongoing contract, either party can terminate the ongoing relationship at will. Merchant form offer. Standard contract law dictates that an offer can be revoked anytime before it's accepted. The UCC creates an exception when a merchant offers to sell or buy goods. If a merchant offerer promises in a signed writing to keep an offer open, then the merchant's offer is valid and cannot be revoked unilaterally. The offer must be written and signed by the merchant. This rule is unique because no consideration is required. The rationale is that merchants having more knowledge and experience with the goods in question should be held to their word. Acceptance under the UCC. Under the UCC, acceptance may be given in any reasonable manner. For example, promising to ship or actually shipping conforming goods constitute acceptance. Under the common law, if they are free as any terms, the law would treat it as a counteroffer. The UCC does not use this mirror image rule. Rather, the UCC allows a contract to be formed if the offeree's response shows a definite acceptance of the offer, even if the acceptance includes terms additional to or different from those contained in the offer. The statute of fraud. The statute of fraud requires that certain agreement must be evidenced by a fraud. Contracts between merchants. If both parties are merchant, court will enforce an oral agreement. If after coming to an oral agreement, one of the parties sends a signed confirmation to the other merchant within a reasonable time. So this is the summary that I studied this week about UCC contract.